The topic about proceedings in which no hearing is required. In many situations, a hearing is required neither by statute regulations nor by the due process provision. Number one, due process dependent upon the circumstances, while a day in court is a matter of right in judicial proceedings. It is otherwise in administrative proceedings, since the rest upon different principles. In some instances, even a hearing and notice are not required. This is especially true where much must be left to the discretion of administrative officers in applying a law to particular cases. And number two, nature of right affected notice of hearing are necessary in order to comply with due process of law. Only when constitutional right is claimed to be invaded, the Constitution does not require a trial type hearing in every conceivable case of government impairment of private interest. For instance, letter A, many cases have held that of an administrative determination is to decide whether a right or privilege which an um, applicant does not possess shall be granted to him or withheld in the exercise of an discretion vested by a statute. A notice and hearing is not necessary in the absence of an express or um, implied statutory provision. Therefore, and a statute may provide for such determination without requiring notice and hearing. And letter B, if no personal or property rights are involved, by only a privilege notice or hearing may not be essential to due process law, even though the process exercise is recognized as quasi-judicial or adjudicatory, particularly where the statute provides for judicial review of the administrative determination. And letter C, similarly, where a right is granted conditionally and subject to termination, it may be withdrawn in accordance with the conditions subject to which it was received, including the absence of any right to hearing. Thus, the revocation of a temporary permit or removal of an acting temporary employee may be affected without notice or hearing. Nature of power exercise. The requirement of notice and hearing is not essential where the proceedings or power exercise is legislative, executive, administrative, or ministerial in nature, and not judicial, quasi-judicial, or adjudicatory, or the government is engaged in the dispatch of its internal affairs. However, such a proceedings may not be used as a vehicle of depriving a person of constitutionally protected rights without such hearing. And letter A, there are many cases in which powers of determinations and action of a quasi-judicial character are given to officers by which not only the property but the lives of individuals may be affected, and which from their nature must be exercised summarily and without a prior hearing or even notice to the parties who may be affected. Thus, prior notice and hearing are not required for the summary abatement of nuisance per se which affect the immediate safety of person and property. Or second, in summary proceedings in distrains and levy upon the property of a delinquent taxpayer for the collection of internal revenue taxes, fees or charges are any increment thereto, or number 3, in the preventive suspension of a public officer's pending investigation. It is a constitutional commonplace that the ordinary requirements of procedural due process yield to the necessities of protecting vital public interests through the exercise of police power. A letter B. Usually, however, cases upholding the right to take such summary action in cases of emergency or necessity recognize a right to a hearing and relief, after which a sufficient can afford due process of law. Thus, the Supreme Court has upheld the authority of the regulatory boards to grant ex parte provisional relief upon the filing of an application, petition, or complaint, or at any stage thereafter, and without the need of hearing as granted to them by law. But it shall call a hearing thereafter for the determination of its final decision. The, the order granting such provisional relief, however, must be based on substantive evidence, supporting papers duly verified and authenticated, and is without prejudice to rendition of a final decision after a hearing. Such a provisional order, as akin to temporary restraining order or a right of preliminary attachment issued by the courts, which are given ex parte and which are subject to the resolution of the main case. Letter C. No notice and hearing are necessary where an administrative agency, example, Board of Immigration Commissioner, merely pass upon the sufficiency of the evidence presented before an office. Example, Board of Special Inquiry, under it evade criminal prosecution. The Secretary of Foreign Affairs, in the exercise of his discretion to revoke a passport already issued, cannot be held to have acted whimsically, capriciously in withdrawing and canceling such passport. And number 2, hearing not always necessary or required. Due process does not necessarily mean or requires a hearing. With discretion is exercised by an officer vested with it upon an undisputed fact, such as the filing of a serious criminal charge against the passport holding. Hearing may be dispensed with by such officer as a prerequisite to the cancellation of his passport. Lack of such hearing does not violate the due process of law clause of the Constitution, and the exercise of the discretion vested in him cannot be deemed whimsical and capricious because of the absence of such hearing. If hearing should always be held in order to comply with the due process of law clause of the Constitution, then a right of preliminary injunction issued ex parte would be violate of the said clause. Facts of the case: petitioner appellate B, an American citizen, was allowed to stay in this country for 3 years as a pre-arranged employee of the Bismarck Production Incorporated, of which he is president and general manager. He applied for extension of stay with the Bureau of Immigration in a letter dated July 10, 1959. In view, however, of confidential and damaging reports of an immigration officer to the affected that the Bismarck Production Incorporated is more of a gambling front than the enterprise for promotion of local and imported shows that it purports to be, and that B is suspected of having invaded payments of his income tax. The Commissioner of Immigration advised him that his application for extension of stay as a prearranged employee has been denied by the Board of Commissioners, and he should depart within 5 days thereafter. Counsel of Bir requested for a copy of the uh, adverse decision of said board. B was simply advised of said denial. No request for reinvestigation was made with the Bureau of Immigration. Instead, to forestall his arrest and the filing of the correspondence deportation proceedings, B filed a petition for prohibition pending resolution of the main case for prohibition. A right of preliminary injunction was issued ex parte by the court, a Q on the same day, ordering herein respondents appellant to desist from arresting and detaining petitioner appellant during the hearing on the documentary evidence were presented. Held um, no the court said no extension of stay of aliens purely discretionary and the part of the immigration authorities. The administration of immigration laws is the primary and exclusive responsibility of the executive branch of the government. Extension of stay of aliens to purely discretionary or on the part of the immigration authorities. Since Commonwealth Act number 613, otherwise known as the Philippine Immigration Act of 1940, is silent as to be procedure to be followed in this case. We are inclined to uphold the argument that courts have no jurisdiction to review the purely administrative practice of immigration authorities of not granting for formal hearing in certain cases as the circumstances may warrant, for reasons of practicability and expediency. And number two, a day in court, not a matter of right in administrative proceedings. This would not violate the due process clause if we take into account that in this particular case, the letter of appellant, commissioner advising B to depart in 5 days is a formality, a preliminary step, and therefore far from the final because, as alleged in appellant answer to the complaint, the requirement to leave before the start of the deportation proceedings is only an advice to the party that unless to departs voluntarily, the states will be compelled to take steps for his expulsion. It is already a settled rule in this jurisdiction that a day in courts is not a matter of right in administrative proceedings. And lastly, right to notice and hearing not always essential to due process of law. The fact should not lose sight that we are dealing with administrative proceedings and not with judicial proceedings. And Ayan. That's all. Thank you.
Good evening, ma'am. Good evening, classmates. My name is JOCELYN P. DULDULAO, ABPS 34. I'm going to report my topic about the administrative proceedings. Applicability of rules governing judicial proceedings, the difference in origin and function of courts and as administrative agency preclude the wholesale transportation of administrative proceedings of the rules of procedures, trial, and review, which they involve from the history and experience of courts. The provisional of the rules of court may be applied suppletorily to proceedings before an administrative body with quasi-judicial powers only in the absence of different and valid statutory or administrative provision prescribing the grounds, rules for the investigations, hearing, and adjudications of case before it. Number 1, strict legal rules not applicable. Usually, the procedure of administrative agency is not formal and strict in that of the court is regularly such proceedings is not be tested by the strict legal rules and prevail in courts of law. Number 2, due process requirements to be observed, although administrative agencies are as null unrestricted by the technical or formal rules, procedures applicable to courts in the adjudication. In case of administrative agency, the same of courts must be within the cannot exceed the jurisdiction, not entirely dispense with the basic rules in providing allegations. Delegations of authority to hear and receive the evidence. It is well settled that while the powers to decide reside solely in the administrative agency vested by the law does not preclude a delegation of the power to other persons such as hearing officers, examiners, and investigators. To receive evidence, hold a hearing, and make reports, the basis which the decision of the administrative agency will be made from the administrative body or agency. Include the subordinate officials upon those hand and the body or delegates a portion of its authority, such a procedure in a practical necessarily. Insufficient that the judgment and the discretion finally exercised are those the officers authorized by law. Number 1, essential judgment and discretion are finally enriched by proper officers. Number 2, essential that due process requirements are observed. Neither due the process of law or requirements of their hearing requires as the law actually testimony before the same officers who will make the decision of the case. Number 3, essential that proper officer acts in his own depending judgment. It is however required that to give the absence of hearing, which is the purpose of the making determination upon the evidence, or the officers who makes the personal considered and appraise the evidence which justify them. He must be on his own independent consideration of the law or facts the controversy and simply accept with the views of recommendation of such subordinate in arriving at a decision. That is how the administrative proceedings flow. That's all. Thank you.
Hi ma'am, hi classmates. This is my topic report. Controversies among government offices and corporations. Number 1, how settled? All disputes, claims, and controversies solely between or among the departments, bureaus, offices, agencies, and instrumentalities of the national government, including government-owned or controlled corporations, such as those arising from the interpretation and application of statutes, contracts, or agreements shall be administratively settled or adjudicated in the manner provided in Book 4, Chapter 14, of the Administrative Code. This chapter shall, however, not apply to disputes involving the Congress, the Supreme Court, the Constitutional Commissions, and local governments. Number 2. Disputes involving questions of law. All cases involving only questions of law shall be submitted to and settled or adjudicated by the Secretary of Justice as Attorney General of the National Government and as ex officio legal advisor of all government-owned or controlled corporations. His ruling or decisions thereon shall be conclusive and binding on all the parties concerned. Number 3. Disputes involving questions of lack of fact and law. Cases involving mixed questions of law and of fact or any or only factual issues shall be submitted to and settled or adjudicated by A. The Solicitor General if the dispute, claim, or controversies involves only departments, bureaus, offices, and other agencies of the national government, as well as government-owned or controlled corporations or entities of whom he is the principal law officer or general counsel. And letter B, the Secretary of Justice in all other cases not falling under paragraph 1. Number 4, arbitration. The determination of factual issues may be referred to an arbitration panel composed of one representative each of the parties involved and presided over by a representative of the Secretary of Justice or the Solicitor General, as the case may be. Number 5, Appels. The decision of the Secretary of Justice as well as that of the Solicitor General, when approved by the Secretary of Justice, shall be final and binding upon the parties involved. Appeals may, however, be taken the President where the amount of the claim or the value of the property exceeds 1 million pesos. The decision of the President shall be final. Number 6, rules and regulations. The Secretary of Justice shall promulgate the rules and regulations necessary to carry out the provisions of Chapter 14. Yun lang po. Thank you.
Good afternoon, ma'am. My name is ERIKKA CABANGON, ABPS 34, and today I will be going to report the evidence of administrative proceedings. So first, let me define what is evidence of administrative proceedings. So it is a non-judicial determination of fault or wrongdoing and may include in some cases penalties of various forms, and they are typically conducted by the government or the military institution. So the first one is the application of strict rules of evidence. So an administrative agency is not bound by the strict rules governing the receptions of evidence in court proceedings. The obvious purpose is to free administrative bodies from the compulsion applying technical rules so that the mere admission of the matter which would be deemed incompetent in judicial proceedings would not invalidate the administrative determination. So the term strict rules of evidence is most commonly used to specify that they are not to be followed, and the most common context for this is when the case is goes to arbitration instead to court of law. And at times the strict rules of evidence are used to define the certain kinds of court cases. And number 2, particular judicial rules. This view has been applied in regard to the best evidence rule, and they have 2 principles. The first one is the res inter alis acta, or the principle that transaction between 2 parties should not be used against the third party. And the second one is res gestae, expert and opinion evidence, privilege of witnesses proper, authentication of records, the use of interrogatories, and the rule as to contradiction of one's own witness. And the number 3, essential rules of evidence. Among the basic essential rules of evidence which an administrative agency has been required to observe, even though it is not bound by the strict or technical judicial rules, are given to evidence under the oath. The principle that evidence must have probative value, proper allocation of burden of proof, the degree of proof, and the right to know the evidence submitted are to be considered, and to cross-examine witness and offer evidence in explanation for the rebuttal. And the number 4 is probative value. Evidence which is sufficiently useful to prove something important in a trial. However, probative value of proposed evidence must be weighed by the trial judge against prejudicing in the minds of jurors towards the opposing party of criminal defendant. So, the probative value, not only there be some evidence to support the finding or the conclusion, but the evidence must be substantial. And the number 5 is hearsay rule, and in a legal form, forum is a testimony from a witness under oath who is reciting out of court or the statement or the content of which is being offered to prove the truth of the matter asserted. In most courts, hearsay evidence is inadmissible unless an exception to the hearsay rule applies. And the number 6, admissions and declarations. Dying declarations of deceased person against interest and other admission and declaration against interest have been held admissible in administrative proceeding, but serving declaration are a general rule excluded. And number 7, evidence offered during the hearing. So, dito naman, all the parties in administrative proceeding must be fully and fairly appraised of the evidence submitted to be considered, and the decision must be rendered on what evidence presented at the hearing. And the number 8, agency files and records. So it is the most important. The court have generally held that it is the improper for an administrative agency in a quasi-judicial or adjudicatory proceeding to base its decision or finding upon facts gathered from its own files without introducing the files in evidence, or upon fact obtained from other cases pending before the previously decided by the tribunal. And on the other hand, there are cases holding that an administrative agency can take judicial notice of its own records or decision, or maybe act on the knowledge of matters disclosed through its own records. And it better to be seen in an administrative agency may take notice of data on file or result reached by in other cases where such is made known there is an adequate opportunity for the rebuttal. And the number 9 is secret or confidential information. So, this is a general rule that in adjudicatory proceedings involving primarily the interest of private litigants, information cannot be held from the parties on the ground that is confidential nature at the same time to be used as a basis for the decision by the administrative agency. However, there are cases which support the proposition that in some instances, right to a hearing does not include to know information which must be kept secret in the public interest. And the last one is the quantum of proof. Is the amount of evidence needed, the quality of proof is how reliable such evidence should be considered, and it is the important rules to govern admissibility concern hearsay, authentication, relevance, privilege, witnesses, opinions, expert testimony, identification, and rules of physical evidence. And that's all. Thank you.
Good day everyone, I'm Dianne BUGATAN. I'm going to report the sum of case on behalf of cases. The first is a phase of complex of evidence of the antiquity of the existing service. The Public Service Commission, which is PSC, has sued for discover the truth through an on-the-ground inspection and observation by its own agent. So the petition there is State of Florencio P. Buwan, and the respondents is the Pampanga Bus Company and the La Mallorca, 99 Philippines 373. So that facts was the State of Florencio P. Buwan is an authorized bus operator along various lines in the Central Luzon, Northern Luzon, with authority to operate 8 auto-track along the Manila-Bacag line and 11 along the Moron-Dimalopihan line. Allegedly, because of resolution of Municipalities Council of Petition by the Civic of Labor Group, Buwan applied in 4 cases in the Commission for the Certificate of Public Convenience to operate the additional trips between Manila and various municipalities and various Bataan, with a total of 83 units distributed. The Pampanga Bus Company or PBC and the La Mallorca LM oppose, allegedly that they are authorized to operate and they are actually operated on the lines and so the Public Service Commission denied the application of Buwan, which is the 4 cases, stated that the service provided by the PBC and LM is where the etiquette was sufficient for the actual needs of the public, and the grant of the application would only return in the necessary or wasteful competition. So the MR denied those the petition to review. So the issue there is one, the service provided by the PBC and LM and Buwan as the already adequate and sufficient to serve the public needs. So the decision below is affirmed with the cause against the petition. So the court does not recognize that 2 respondents companies are liable for some disciplinary action, but such a ground is not enough to authorize the additional trip to Buwan, since the commission is already found that there is already more than adequate service for the said trips. Next is Court of Industrial Relation authorized layoff of workers solely on the basis of the ocular inspection. The Philippines Movie Pictures Workers Association is the petitioners versus the Premium Production INC is the respondents, 92 Philippines 844. The facts is the respondents filed with the Court of the Industrial Relation, which is CIR, an urgent petition seeking authority to lay off 44 men working in its department. First batch to be delayed of 30 days the film after the filming petition, and the rest is 45 days. Thereafter, the respondents oppose, alleging the claim of financial losses has no basis. Whose the urgent petition was set for the hearing is the request of the counsel for the respondents. Judge Roldan on the CIR held an ocular inspection of the studio and filming premises by the respondents. He interrogated about the 15 laborers who are present in that day or in that place. A subsequent hearing was held on connection with the workers assigned to the unit number 1, and on the strength of the evidence submitted by the respondent, the Judge Roldan against found for the petition justification and authorized to their layoff in order to under the same condition of those contained in this previous order. So the issue there is, may the CIR authorize the layoff of the workers on the basis of the ocular inspection without receiving the full evidence of the cause of the motive layoff. So the petitioner moved to the reconsideration of both orders. So the court denied this petition for the review. So the petition, this petition for the certiorari are hereby denied, and the cases are ordered for the remanded to the CIR for the further proceeding. Is no cost. The last case is findings of Workmen's Compensation Commission are not supposed by substantial evidence. Klenya Oy is the petitioner versus the Workmen's Compensation Commission is the respondents. 97 Scra 255. The facts was Kim Lam Oy was the overseas of Jose Perez in her rice mill business. Kim Lam Oy was killed on robbery in keeping the business of Jose Perez. The heirs of Kim Lam Oy was filed on claim on the Workers' Compensation Commission being an employee of Jose Perez. When the Workers' Compensation Commission give a due notice to Jose Perez regarding the latter to submit the WCC reforms the latter failed in to comply to the WCC imposed penalty to Jose Perez to pay the heirs of the deceased of compensation. Jose Perez denied that the deceased were here and employee, as there was no employee and employee year relationship existed. This issue are reached to the Workers' Compensation Commission on appeal of WCC renders a decision that there was no employee and employer relationship, so no compensation was needed to speak up. The aggrieved or aggressive by the decision that the heirs of Kim Lam Oy filed a petition to certiorari before the Supreme Court. So the issue there first is Lucifer's her answer to the instant petition claims that the petition not being verified by the petitioners, but there are counsel to fatally defective. Second is the private respondent content that was raised of the claimant petitions are findings of fact of respondents' Workmen Compensation Commission, which is definitely within the province of appeal, are not for the certiorari. Therefore, the decision of respondents, which is Workmen Compensation Commission, is hereby revised and set aside. The respondent's employee is hereby ordered first is to pay the petitioner claimants the sum of 3,000 pesos as death benefits. Second is to pay the petitioner claimant's attorney fees equivalent to 10% of the total award. And the third is to the last one is to pay the successor of the defiant commission of administrative fees and to pay the cost. That's all. Thank you.
Good morning, ma'am. Good morning, classmates. My report is all about decisions or orders. First, we need to define what is decisions or orders. So, decisions refers to the both administrative and judicial determination. It involves final judgment, ruling, and provisionary orders made by the court. There are three important things about the decisions or orders. First is the necessity of findings. The necessity of the finding, it is the right to cite the evidence without the corresponding duty on the part of the administrative agency to consider is vain. This means that if the evidence is without the corresponding duty of the administrative agency, it must be considered useless. While the duty to deliberate does not often impose the obligation to decide right, it does not imply a necessity of having something to support its decision. A decision or order with absolutely nothing to support it is nullity, or at least when attacked directly. The decision must be based on the evidence presented at the hearing, or at least contain the record or disclose to the parties affected. The important thing is the necessity of finding that the decision must be based on the true evidence presented at the hearing.
What is an administrative agency? An administrative agency is a general term that can act as an executive body that serves public interest, which is the reason for its existence. It shall not represent any private interest. Purpose of administrative agency. An administrative body or agency is any government authority, other than a court and a legislature, that affects the state and its citizens through rulemaking, adjudication, and implementation. Its functions are primarily executive, but it exercises some form of legislative and judicial powers. Where administrative agency is a collegiate body. The powers and duties of an administrative agency or base composed of members or commissioners may not be exercised by the individual members separately. Their acts are official only when done by the members convened in session, upon a concurrence of at least a majority with at least a quorum present. Where the action needed is not of the individuals composing of a board but of the official body, the members must be together and act in their official capacity, and the action should appear in the records of the board. In a case where the former immigration commissioner appeared to have acted individually and not collectively as a board to discuss and vote on a case before it is shown by the different dates affixed to their signatures, the Supreme Court nullified the decision rendered. Individual action by members of a board plainly renders nugatory the purpose of its constitution as a board. The legislature organized the Board of Commissioners precisely in order that they should deliberately collectively and in order that their views and ideas should be exchanged and examined before reaching a conclusion. This process is of the essence of a board's action, save where the otherwise provided by law, and the salutary effects of the rule will be lost where the members act individually, without benefit of discussion. Power of administrative agencies to modify their decisions. Number 1. Conditions. Broadly expressed, administrative determinations are subject to reconsideration and changes so long no rights have vested in the meantime by reason thereof, and so long as they have not passed beyond the control of the administrative authorities. as where the determinations were not final but interlocutory, or where the powers and jurisdictions of the administrative authorities are continuing in character. Number 2. Grounds. In particular, the administrative authorities have the power to modify their determinations on the ground of fraud of imposition, mistake, surprise, inadvertence, or newly discovered evidence, or to meet the changed conditions, whether the reason of express statutory provision granting the power of revision or by reason of principles applied by courts. Conformably with the above rules, it has been held that the decision of immigration officials do not preclude the immigration authorities from reopening or modifying the same. A deportation proceeding decided by the Board of Immigration Commissioners may be reopened a year later through a
Good evening, classmate. I'm RONIEL D. Domingo, ABPS 33. My report is all about administrative appeal and review. The administrative appeals is a request addressed to a public authority by which the aggrieved interested persons demands administrative measure to be taken regarding an administrative act, annulment, modification, or even issuance of a new act. When the letter has been refused by the administration. Types of administrative appeal and review. The administrative appeal can be addressed to the authority that issued the unlawful act, contestation, opposition, recourse, gracious, appeal in reconsideration, or remonstrance, or to its superior body, hierarchical appeal, or recourse. There is also the so-called quasi-hierarchical appeal, external or sometimes recourse. The tackle address to an agency that is not the superior body of the issuer of the act but has the power to control such decision. What the role of the tribunal in the system of administrative law is to review administrative decision on the merits, that is, to consider afresh the facts, law and policy relevant to a decision under review and decide whether that decision under review and decide whether that should be affirmed, varied, or set aside.
Hello ma'am, my name is MICAH BASILAN and my report is all about the illustrative cases under the execution pending appeal, where the legislature has seen fit to declare that the decision of quasi-judicial agency is immediately final and executory. So when we say quasi-judicial agency, it is a non-judicial body that can interpret law. So the law expressly so provides, otherwise execution of decision takes place only when they become final and executory. So yung mga cases na babanggitin ko is, ito yung mga example na cases na yung mga quasi-judicial agency, yung nagkaroon ng authority para magdesisyon sa isang law. So sa mga cases na babanggitin ko mamaya is, ito yung mga cases na yung mga issue niya is kung may karapatan ba yung mga quasi-judicial agency na mag-decision sa isang kaso. So, ayun. So, one of the cases is all about Petitioner Y, which an alien was prosecuted without the intervention of the Commission of Immigration by fiscal for non-exhibition of his alien certificate of registration. So, the facts of this case is Petitioner Y was found by members of Manila Police who was acting suspiciously, and he was placed under arrest. So, in his possession, they find a Chinese wedding list, and to establish his identity and other personal circumstances, he was required to produce his alien certificate of registration, which he failed to do, as a result of which the Office of the City Fiscal filed 2 complaints against him. So, one for the violation of the gambling law of the revised penal code in the Court of First Instance of Manila, and another complaint for violation of Section 7 of Republic Act Number 562 as amended in the Municipal Court of the same city. So, yun nangyari is nag-file yung Office of the City Fiscal, nag-file sila ng 2 complaint kay Petitioner Y. So, yung isa, yung violation sa gambling law, and yung isa naman is yung violation sa revised sa Section 7 of Republic Act Number 562. So, the issue of this case is, thus the Assistant City Fiscal have the authority to initiate the prosecution and the judge, the jurisdiction, to take cognizance of the case. So, yung issue is, meron bang authority yung Assistant City Fiscal na mag-initiate ng prosecution and yung judge para may jurisdiction ba siya sa case na to, yung Assistant City Fiscal. So, yun yung issue ng case na to. So, the rulings of the court is none, because Commissioner Immigration given option by the rulings of the court is none. Commissioner Immigration given option by law to subject erring alien to administrative fine, the original provisions of Section 7 of Republic Act 562 provided for the punishments of violations of its provision, namely failure to exhibit the certificate of registration when demanded by any immigration official or member of the Philippine Police. So, it introduces the intervention of the Commissioner of Immigration in the sense that he has the choice or option to either subject the erring alien to an administrative fine or endorse his prosecution before the court. So, the logical conclusion is that the prosecuting official may not initiate prosecution until and unless the Commissioner of Immigration has elected and decided upon said prosecution. So, yung decision ng court is walang authority yung City Fiscal, because they cannot initiate the prosecution until and unless the Commissioner of Immigration is may na-elect sila or mayroon silang na-desisyonan dun sa kaso na yun. So, walang authority yung fiscal, walang authority fiscal or the prosecuting official to initiate the case of Petitioner Y. The next case is Petitioner H, wherein the constitutionality of law empowering the Workmen's Compensation Commission to execute its award is questioned. So, the facts of this case is H filed a notice of claim for compensation with the Regional Office of Department of Labor for injury sustained by him while under the employ of a petitioner B. So, an award was issued in favor of the wife and children of H who in the meantime died from complications resulting from the injury suffered. So, the award having been declared final and executory by the WCC or Workmen's Compensation Commission, which remanded the case after review to Regional Office for appropriate action, said Regional Office issued a writ of execution against the properties of A. So, the issue of the case is Section 17 of Republic Act Number 4119 is unconstitutional, and therefore, the Commission or its duly deputized officials have no authority to issue a writ of execution. So, yung issue is, yung Section 17 ba of Republic Act Number 4119 is unconstitutional, and Therefore, the commission or yung mga officials ay wala silang authority para mag-issue ng writ of execution. So, the rulings of the court is no. Power of WCC to enforce its award transferred to it from courts of justice as stated in 51 Republic Act number 3428. So, as the law now stands, however, the power to enforce awards under the WCC Act is expressly vested in the Commission or the duly deputized officials in the regional office of the Department of Labor. So, the said writ is therefore null and void. So, yung writ of execution na nilabas ng duly deputized officials it's therefore null and void dahil wala silang authority na mag-issue ng ganun. The last case is all about the case of P, wherein the former employee seeks without an ordinary action issuance by a court of a writ of execution of a decision rendered by the Wage Administration Service against his employer. So, the facts of the case, P, a former bus inspector of a public utility operator, filed with the Wage Administration Service a claim or complaint for unpaid overtime compensation, unjust dismissal, and vacation, and sick leave pay allegedly due him from said employer. So, Wage Administration Service investigator recommended the rendition of a decision finding that P was entitled to aggregate sum of 8,569.75 and requiring the employer to deposit this sum to the WAS within a specified period. So, over a year late, P filed a petition alleging that he had filed said complaint with the WAS that the latter had rendered the aforementioned decision and that said decision had become final and executory. So, the issue of the case is whether the decision of the WAS finding that P is entitled to recover 8,359.75 may be ordered executed by a court of justice. So, yung issue ng case na petitioner P is yung decision ba ng Wage Administration Service na si P ay naka-entitled para bayaran yung 8,359.75 may be executed by a court of justice, may be ordered executed by a court of justice. So, the rulings of the court is, the answer must be negative because neither the lower court nor the appellee had cited any provision sanctioning the procedure followed in this case by the lower court. So, what is more, the law creating that the WAS indicates clearly that an action must be brought in any competent court for the recovery of unpaid wages which the employer fails or refuses to satisfy. So, it is apparent that the authority to bring an action for the recovery of wages due an employee or labor would not have been explicitly vested in the Wage Administration Service. So, those three cases were the example of the executory pending appeal, where the legislature has seen fit to declare that decision of quasi-judicial agency is immediately final and executory pending appeal. So, otherwise, execution of decision takes place only when they become final and executory. So, that is all, and thank you.